is to be able to win back the battle of work intensity, to actually get into the nitty-gritty of work intensity. I'm sorry, I didn't think about bringing a clip. We have a clip on actually auto factory operating under the Japanese system of Kaizen, which is mind-boggling, of a human body performing more than 60 tasks, 79 I think in less than 60 seconds. So this is really a human body moving like a robo. Probably no robo can move at that speed. That's something to think about. So and that Karamat also sort of in fact began with that, which was the Factories Act. The clip talked about issues of health and safety. Regulating the workplace is about health and safety. It's about regulating working hours. It's actually about a reproducible human body. I mean, if we believe the human body is there for reproduction, then work intensity is something that we need to connect. It's not just that profits are a company's needs. It's also about the human need to reproduce, which work intensity completely varies. And I think that's the sort of second part, as it were, that's critical to all forms of labor law regulation, but also really the source of the pressure for irregular forms and informal forms of employment and recruitment. I'm going to end on looking at how labor law is, and I think that's both important and instructive. Look at where the labor law transition is taking place. India makes for an interesting case. It's interesting to note that in Bangladesh there was an attempt to codify multiple labor law in 2006 in the form of the Bangladesh Labour Act. There's been an attempt very much more recently, especially after the sort of federalization of law of the constitution in Pakistan, also to rewrite labor law. And of course, there have been amendments to the Factories Act in just about all countries of the subcontinent, which have really allowed government companies, most notably, to function at levels of wages and work intensity that they are doing. Indian labor law, or the Indian labor code, so to speak, has barely been through a change in the last 20 years, apart from the rule book. I mean, I'd make a distinction between the statute and the rule book. But India, this is not to say that India is a free or fair country in terms of labor. What Suzuki and others instances show us that the conditions are horrible by any stretch of imagination. In India, the code, so to speak, has not been rewritten by executive or by legislature, but it's been rewritten by judiciary. So it's important. So, you have a militarization, so to speak. If I were to carry on with Karamat's metaphor, you have actually the judiciary that's leading the police state when it comes to labor rights. So what's happened in the last 10 years, starting with the year 2000, if one looks at that, so 10 years into neoliberalism, it's the judiciary that's reinterpreted not just the statute book, but its own judgments. And I think there are two judgments that stand out. One that really codifies, so to speak, the right to employ irregular labor, which is the judgment on contract labor of the Steel Authority of India. And of course the second, which apart from sort of completely throwing to the winds the idea of regular employment, is the case of Ramadevi versus the state of Karnataka. It's important not just for the fact that the Supreme Court held that you need not, that a sustained period of employment, in this case 240 days over several years, was not enough for regular employment. To me, what's more important about that judgment is the Supreme Court actually told the lower courts, don't read the statute, read us. Because the Ramadevi case is a case in which this was somebody who was a non-permanent employee of the government of Karnataka, sort of manual worker of some kind or another, I forget the category. Yeah, so we're not dealing with a senior sort of white-collar civil servant or something like that. In the industrial tribunal, in the High Court, and in the division bench of the Karnataka High Court, it all upheld Ramadevi's case. The Supreme Court that turned the case against her, but also told the three courts lower than it that we expect the honorable lower courts, if I remember that language, they are honorable but lower nevertheless, to read the judgments of this court. And I think that really sets, I think, what's happening to the Labour Code in India, that there is a Supreme Court which is sort of leading, if not the militarization, certainly leading the policization of labor rights. And if I can go back to sort of just one bit of the Suzuki story, it was the Chandigarh High Court that was ruling industrial action of the Suzuki workers in 2011 as illegal, despite the fact that there was no report from the Labour Department. There was in fact before the court only a report by the police department of the district. I'll stop here. Thank you.